$0. That's what a widow can be left with, on a pension her husband paid into for 30 years, if one box was checked wrong on a form neither of them remembers signing. Not reduced, not delayed. 0. Permanently, the month after the funeral, with no appeal process most widows even know exists. Picture the version of this that plays out quietly in thousands of households every year. A husband retires, fills out a stack of paperwork during a single meeting with HR, checks a box that promises him a slightly bigger monthly check for the rest of his life, and neither he nor his wife thinks about that decision again for 20, 30 years. He passes away. The pension check that arrived like clockwork every month simply stops, and calling the plan administrator produces an answer nobody wants to hear. He elected the option that pays only during his own lifetime, and the plan is under no further obligation once he's gone. 6 words explain almost everything about how this happens. Single life versus joint survivor. Every traditional pension retirement includes this exact choice, and the difference between the two options is the entire subject of this video. First, I'll walk through the mechanism itself, why this choice exists, and why it catches spouses off guard decades later. Second, you'll see a real case, a widow I'll call Frances, so the stakes stop being abstract. Third, I'll give you the specific steps to check your own situation this week, including a legal protection most spouses don't know exists. And stay through the end, because there's a second trap tied to this one, buried specifically inside pensions from companies that later went out of business or restructured. The choice nobody remembers making. Traditional pensions, the kind that pay a set monthly amount for life rather than a lump sum, force a decision at the moment of retirement. Option 1, called a single life annuity, pays the largest possible monthly amount, but the payments stop entirely the day the retiree dies. Option 2, called a joint and survivor annuity, pays a smaller monthly amount during the retiree's lifetime in exchange for a portion of that income, often 50, 75, or even 100%, continuing to a surviving spouse for the rest of her life. On paper, this looks like a simple trade-off between more money now and protection later. In practice, the decision gets made once, usually during a retirement paperwork session that also covers health insurance, tax withholding, and a half dozen other choices, all crammed into a single appointment. The dollar difference between the two options can look small on a monthly basis, sometimes only a few $100s, which makes the higher single life number feel like the obviously better choice if nobody walks through what happens on the other side of it. Congress anticipated this problem decades ago. Under a federal law called ERISA, a married pension holder generally cannot elect the single life option, the one that leaves a spouse with nothing, without that spouse's written, notarized consent. The law assumes both people in the marriage understand exactly what's being given up. The signature requirement exists specifically so a husband can't quietly choose the higher payout without his wife's knowledge or agreement. Here's where the protection breaks down in practice, though. Decades pass. Memories fade. Some spouses signed a consent form in a stack of dozens of retirement documents without fully absorbing what it meant, trusting that whatever their husband decided was fine. Others don't remember signing anything at all, and when they finally see the original paperwork years later, the signature looks unfamiliar, rushed, or simply wrong. Neither situation is rare. Both leave a widow in the same position, a pension that stopped paying, and a signature on file that either she doesn't recall or that may not be genuinely hers. Retirement paperwork sessions are rarely built for careful reflection. A husband nearing retirement typically sits across from an HR representative or benefits coordinator for a single appointment, working through health insurance elections, tax withholding forms, beneficiary designations for other accounts, and the pension election all in the same hour or two. The spousal consent line is usually one signature among many, presented as a formality to complete, rather than a decision with permanent, irreversible consequences. Nobody in that room is incentivized to slow the process down and walk through what a single life election actually means 20 or 30 years later. Because from the plan's perspective, the appointment's purpose is simply to get the paperwork signed and filed correctly. Frances and the missing signature. Let me walk through exactly how this played out for one widow, because the mechanics only really land once you see how ordinary the whole situation looked from the outside. Frances's husband worked for a manufacturing company for 31 years before retiring at 65. Their retirement felt financially secure, a decent pension, both of their Social Security benefits, modest savings. When he passed away 11 years into retirement, Frances called the pension administrator to update the mailing address for what she assumed would be a continuing survivor check. Instead, she was told the pension had elected the single life option at retirement, meaning payments stopped entirely with his death. 11 years of a stable monthly check simply ended, replacing a meaningful portion of her household income with nothing. The call itself lasted less than 10 minutes, and Frances has said since that the representative on the other end sounded almost bored delivering the news, as though this exact conversation happened often enough to no longer register as unusual. That part stayed with her more than almost anything else. The sense that her situation, devastating from where she sat, was routine and unremarkable from inside the system that created it. Frances didn't remember signing a spousal consent form, but she also didn't remember not signing one. 11 years, and honestly the entire blur of the retirement paperwork process more than a decade before that, had faded into a general impression rather than a specific memory. What she did next is the exact step I want every widow watching this to take. She requested, in writing, a copy of the original pension election paperwork from the plan administrator. Federal law requires these plans to maintain and produce these records, and as the named beneficiary and surviving spouse, she was entitled to see them. When the documents arrived, the spousal consent section did have a signature on it. It simply didn't look like hers. The letters slanted differently than her handwriting typically did. The flow felt unfamiliar, and there was no notary stamp anywhere on the page, despite the form itself stating a notarized signature was required. No stamp meant no proof. Frances brought the documents to an attorney who specializes in ERISA benefit disputes, and after a formal challenge to the plan administrator, the missing notarization and disputed signature were enough to reopen the case. It took several months. Frances had to provide handwriting samples for comparison, submit to a back and forth of written correspondence between her attorney and the plan's legal counsel, and wait through review periods that felt endless while her household income sat reduced. The plan ultimately reinstated a survivor benefit, retroactive to the date of her husband's death, restoring a portion of the income she'd gone without for close to a year while the case was under review. Not every widow's situation resolves this cleanly, and Frances would be the first to say the process was slower and more draining than she expected. But the alternative, simply accepting that the check had stopped and moving on, would have meant permanently losing income that federal law was specifically designed to protect. What to check this week? 3 steps put you in control of this, whether your husband is still living or you're already navigating this as a widow. Request the original pension election paperwork in writing from every plan your husband ever paid into, not only his final employer. Many people worked multiple jobs with pension benefits across a career, and a plan from 20 years earlier can be just as relevant as the most recent one. Plans are required to maintain these records for a set retention period and to produce them for beneficiaries upon request. Compare the spousal consent signature carefully against something you know is genuinely yours from around that time period. A signed check, an old form, anything dated close to the retirement election. Look specifically for a notary stamp or witness signature, since most spousal consent requirements call for notarization, not just a signature. A missing notary stamp on its own can sometimes be enough to challenge an election, even when the signature itself looks plausible. If anything looks wrong, incomplete, or simply doesn't match your memory of the retirement process, contact an ERISA benefits attorney or your regional Employee Benefits Security Administration office before assuming there's nothing to be done. Many of these attorneys offer a free initial consultation specifically because ERISA cases like this one are common enough that assessing whether a case has merit takes only a short conversation. One additional detail worth knowing before that conversation: the length of time since your husband's retirement doesn't automatically bar a challenge. ERISA claims involving improperly executed spousal consent have succeeded even decades after the original election, because the underlying question isn't how long ago the form was signed, but whether it was ever validly signed and witnessed in the first place. An attorney can tell you quickly whether your specific timeline and documentation give you a reasonable case, but don't rule yourself out simply because the retirement happened a long time ago. The second trap, when the company no longer exists. Here's the version of this trap that catches even widows who did everything right at the original election. If your husband's pension came from a private company that later went bankrupt, was acquired, or simply terminated its pension plan, the survivor benefit you're owed doesn't necessarily disappear. The path to collecting it, though, changes completely, and almost nobody explains this in advance. When a private pension plan terminates, in many cases, a federal agency called the Pension Benefit Guaranty Corporation, usually shortened to PBGC, steps in to take over remaining benefit obligations, up to certain legal limits. This means a survivor benefit that was properly elected years earlier, at a company that no longer exists in any form, can still be collectible. The catch is knowing to file a claim directly with PBGC, rather than trying to reach a defunct company's long-gone HR department. Widows in this situation often assume, understandably, that once a company closes, any pension promises made by that company close with it. That assumption is usually wrong. Discovering it's wrong, though, requires knowing PBGC exists in the first place, which most people never have a reason to learn unless they happen to be in exactly this situation. The fix here starts with a simple search. PBGC maintains a public database of terminated pension plans, searchable by company name, that can confirm whether your husband's former employer's plan was taken over. If it was, filing a claim directly with PBGC opens the path to collecting a survivor benefit that a defunct company can no longer pay directly. Use whatever original pension documentation you have, an old benefit statement, a retirement election form, even old pay stubs referencing the plan, to support the claim. Before you go, I want to be clear about something here. Pension rules, spousal consent requirements, and the specific protections available to you depend heavily on your husband's specific plan, the state the plan operated in, and the exact paperwork on file, which means your situation may differ meaningfully from either Francis's case or the general outline I've walked through. Government pensions, military pensions, and private employer plans each carry slightly different rules, and some older plans predate certain ERISA protections entirely. What I've covered here is general education about how these protections work, not a guarantee of a specific outcome or a substitute for reviewing your actual documents with a qualified attorney. Still, a few things hold true regardless of your specific plan. You are entitled to request and review your husband's original pension election paperwork. Federal law does require spousal consent, properly witnessed, before a single life option can typically be elected. And if a company no longer exists, that doesn't automatically mean the benefit disappeared with it. PBGC exists precisely for situations like that one. If this helped, do 3 things. Like this video so it reaches widows who assume, the way Francis almost did, that a stopped pension check is simply the end of the conversation. Subscribe, because next week covers the safe deposit box trap that catches even families who thought they'd handled every other piece of paperwork correctly. And in the comments, tell me whether your husband's pension is still paying out, or whether it stopped and you're not sure why. I read every one, and if something sounds off in what you describe, I'll do my best to point you toward the right next question to ask. A stop check doesn't always mean a closed case. Sometimes it just means nobody's asked to see the paperwork yet.